just one last second something.
My name is James Lee. I'm the acting head of the School of Humanities and Languages. Oh, background music. I have a very simple job here this morning, and that is to welcome all of you to UNSW and to this event. When I saw the theme for the event, that it was interprofessional dialogue, I thought, well, that's a good thing. And I think probably that you think it's a good thing, or you wouldn't be here. So, welcome to UNSW, welcome to this day. I really want, though, to acknowledge the three organizers of this event. No event can take place without organizers up front and all of the people that work with the organizers behind the scenes. So Sandra Hale from the School of Humanities and Languages is one of our organizers. Ludmilla Stern, also from the School of Humanities and Languages. And I did not get to meet Mira Sandroque from the school. It's not the School of Law.
It is actually both the school and the
and on our branding, your UNSW law. Okay. From the looks of the program, I think it's going to be a really productive day, and I will not waste more time welcoming you, but rather letting you get ahead with the business of the day. So, Ludmilla?
Yeah. Thank you very much, James, for your words of welcome. Welcome, everyone. Welcome those who flew despite the weather and disruptions with the planes. We were worried whether we would be able to run this event. We have some apologies. One is from the Parliamentary Secretary, the Honourable Concetta Fioravanti-Wells, who, for serious family reasons, was unable to attend. Now, today's event was inspired by last year's symposium on legal interpreting here at UNSW. During that symposium, we became aware, probably one more time rather than for the first time, that there are significant differences in the way lawyers and legal interpreters understand the interpreting process, the role boundaries, each other's requirements and needs and challenges that arise during interpreted interaction in the legal setting. And because of that, we decided to run this year, our 5th symposium, as a dialogue. Hence the panel discussion with with representatives of both professions, the legal profession and the interpreters, whom you see on both tables. The panel will be moderated by Professor Cathy Lester, and it will be interspersed throughout with Q&A with the expert audience. The expert audience represent the stakeholders of legal and court interpreting, and there are among you representatives of the government, of private agencies, of the academia, education sector, professional associations, and more. So what do we hope to achieve throughout today's dialogue? Essentially, we hope that lawyers and interpreters will be able to shed light on mutual expectations and needs. We hope that it will help to define role boundaries of both professions, break stereotypes, help the professions to work together more effectively, and generally improve the quality of communication and problem solving. Initially, I thought that I would introduce our panel members and our expert audience one by one, but I think, I hope that the signs in front of the panel participants and later on the interventions from the audience, and we would ask you then to say who you are and which organization you represent, will allow all those present to know who you are. So I would like to thank again the School of Humanities and Languages for supporting and funding this event. I would like to thank the Faculty of Law, through you, Mira, for your ongoing collaboration and support and for providing this lovely venue. And there is probably a lot more that I would like to say. Thank you, Simon, Sean, for allowing us to stream this event. So as this evolves, we are being viewed. So could you please fill in throughout the day the release form that you probably have already found on your seat. So very briefly, after I give the floor to Professor Sandra Hale, Kathy will start moderating the interprofessional panel, which will go on until almost 12 o'clock with a break. There is some water on the side, so please help yourselves. And at 12 o'clock, Associate Professor Uldis Ozelens, our discussant, is going to sum up the results of the dialogue. Hopefully, we will be able to make some recommendations to be implemented. And after that, an informal lunch will be catered, will be brought in, and everybody clearly is invited. So thank you again for being here and for your participation. We look forward to today's discussion. And Sandra, over to you.
Thank you very much, everybody. There's not much else that I need to say after what Ludmilla and James have already said, so I won't spend too much time. The first thing that I want to do is show a little clip, a video clip, which some of you may have seen before on YouTube, and then we'll discuss it a little bit. Okay, can you make it bigger? Yeah? Yeah.
Mr. Interpreter, may I speak with you for a moment before you leave? Yes, of course. It's about this client. What's your take on her? Is she credible? Is she telling the truth? Or do you think she could be holding something back?
I'm sorry, but that's not my area of expertise. I wouldn't be able to say.
Sure, but you're both from the same country. You must have some idea what she's really like, right? I mean, it doesn't take an expert to understand somebody from your own country.
My mandate is to interpret everything that is said by each person and what I may think they really mean. And that's all I'm allowed to do.
Yeah, but surely you must have some impression.
I must remain neutral to all parties at all times.
Not while I'm paying you. I've hired you to work for me, and you'll do things my way, or you won't be hired by my office again.
I'm sorry I cannot help you. I will be sending you an invoice for this afternoon interpreting services. Now, if you will excuse me.
Señor intérprete, ¿le puedo preguntar algo?
We'll just do that. Okay, so as you may have gathered from this, I don't think that was a very successful interprofessional relationship between two professionals, a lawyer and an interpreter. So the question that we will have as a general question today for all of us is, you know, how can this relationship be better? And how, in this situation, how could that have been handled better? How well do the two professions understand each other's roles and needs, and the need for an interprofessional dialogue, which is what we're having now. Often this video is shown to show how interpreters are placed under pressure from both sides, and the other one that we won't show is the pressure from the side of the Spanish speaker in this case, asking the interpreter to do things that go beyond their role. But I deliberately showed that one because I think that the interpreter was not being very helpful either. I don't think that, you know, that very aggressive attitude is justified either. So I think we need to have understanding from both sides, and if one side asks someone or the other side to do something that goes beyond the role or outside of the role, then there's no need to be offended by it or become aggressive. You know, we can always talk and discuss how we would like to work together. So this is the whole aim of today, and I'll pass it over to you, Kathy, so we can start the conversation. Thank you.
Thank you. So can I be a little bit radical? We've got 3 spots down here, it'd be great if we had some volunteers to come, because then we don't have a back row. That's my calculation, that we lose the back row if we can get some people down here and then the back row can come to the second row. So we only have 2. My preference would have been to have a round circle, but I've been told because the wide world of millions of people is watching us, that we can't, you know, we're going viral, hello out there. We can't move the chairs. But could I have just another person and then the back row? I know you're probably the students. That's okay. You can come and be real people in the front row. We have one more spot here. So my name is Kathy Laster. So my area is law. I have a kitchen Hungarian because I was born in Hungary. So I kind of understand some of the complications of language. I also worked as a lawyer before I became an academic. And I probably made all the worst mistakes, actually, because I remember very clearly in a guardianship matter where someone wanted guardianship removed from him, and he came to the tribunal to ask for this order to be removed against him. And he was sweating and he looked terrible and he was white, and I thought, oh no, he looked really mad today. And turns out that in my fantastic professional, you know, bilingual limited skills, I had been using the word for court, which in Hungarian means he's about to go to jail, not the tribunal. So even though I thought he got fantastic legal advice and best possible support at the community legal centre, that didn't work. And then the interpreter arrived, thank goodness, he was able to clarify that. But of course, the other thing the interpreter did by chatting to my client, who did have serious mental health issues, was he was male, he was about the same age, and they were remembering famous brothels in Budapest. Frequently, so my guy completely relaxed. So I have had some experience in there. A very long time ago, I wrote a book on with Veronica Taylor on interpreters in the legal system, and I was a naive academic, and I thought, oh well, I've done the book now, so all the problems will disappear. In fact, the interesting thing is, since 1990, exactly the same issues that our panellists have been bringing forward are still there. So, with your indulgence for 1 minute, because everyone's got a burning issue, and your expectations about what you hope to get out of today very much depend on whether we address that secret niggling issue. So, can I get some sort of quick declaration, if you're spending a half a day of your very valuable time, what is the one thing you think would be really important for you to know or solve or do after today? Is there any suggestions? Something that, you know, I hope they do X. And then meanwhile, you could say who you are too, that would be great.
John Beaver, CEO of NATI, National Accreditation Authority for Translators and Interpreters. The one thing I look to for organisational gatherings like this is better appreciation of the value of trained and certified or accredited professionals.
So by both, by people who are engaged in interpreting, so they need to get qualified, and by lawyers who understand them?
More particularly the latter.
Okay.
I'm Isabel Brown. I'm actually representing Centre for Advantage Wealth, so who is the Parliamentary Secretary with responsibility for multicultural affairs.
Ah, well, you should tell us, what is the one thing Senator Advantage Wealth would like?
I think that what she'd like to hear is what are, say, the 3 burning issues, and what are perhaps the 3 practical solutions that you would seek from government if they were able to.
Okay, I'll pass all of it. Okay, yes.
Thanks, Kathy. My name is Hakan Harman. I'm Chief Executive Officer of Multicultural New South Wales. We are the New South Wales Government agency providing interpreting and translation services. We have an MOU with the Department of Justice and provide all the court and tribunal interpreters in New South Wales. Since taking on this role, we've undertaken a fairly substantial review of our organisation, including now a thorough look at the provision of language services. Having a contemporary understanding of the issues with an intent to build a better service provision from our own agency is really important. And from my perspective, I think this notion that interpreters and translators need to be viewed as professionals. And I think these forums and our support for it, for them on an ongoing basis, is an important part of that image being created.
Okay, so it's the professionalisation and professionalism issues which have come up. Yep. You need to give us piles of money into this area.
No. I'm Director of the Law and Justice Foundation New South Wales, and in a former life I was an Indonesian speaker and concerned interpreting, but in my current role, for the last 15 years, I guess the area of interpreting comes in terms of which support training, but obviously also been involved in a whole range of different. One thing that comes out to me is when there are conceptual differences. I mean, just thinking back an example, I can think of when I was visiting Chinese and trying to give a presentation and talk about the committal stage, for example. China doesn't have a committal stage, so how do we learn the words of cat in Chinese, but if they don't have the concept of cat, how do we do that? And that, at the moment, we have some applications before us in relation to was-no interpreting. So how do we handle interpreting when, and in terms of the qualification, accreditation, and actually performance of interpreting, when there are conceptual issues involved about, the interpreter doesn't understand the concept, and in the legal context, there are some concepts where it's actually doing, what is arraignment, what is, what is bail, how do I explain that, and how does that work in the full spectrum of the interpreter context?
Sure, and that's a fundamental issue of Babel, isn't it?
Hi, I'm Emma Bollage. I'm the Acting Director at Kingston Legal Centre. I guess the most pressing issue in terms of our centre, and I think the community legal sector, is around access to interpreters and access to justice, and looking at increasing pressure on free services, increasing pressure to do more appointments with less time, and also reducing interpreter budget, and also decisions about, well, that's not a priority matter. That we're still really insisting on professional interpreters in all our appointments, but in the wider field there's lots of pressure around that, and I'm not sure a complete understanding about how it's such a significant barrier to access to justice and the role free legal services play.
So you should be just sitting on that
side.
And maybe just right there too. It's fine. Camilla, we know. Sandra, we know. Mara, hi, from the law school. I guess I'm not actually asking this panel to address this question, but what I find particularly interesting and challenging is the issue that was raised in that video, which is about expertise and what types of expertise we're expecting the interpreter to bring to the process, and where those lines can be drawn in terms of expertise in language, expertise in culture, expertise in interpretation of the context in which something is. I find that quite a difficult conceptual process. So these are all fundamentally around professionalism. Yes. So, and I will introduce our panelists here, but I want them to hear what the audience is thinking, so that when we come to their discussions, they can focus on some of the burning issues.
Hi, I'm Alison Rodriguez from Aussie, the Professional Body for Interpreters and Translators, and I would like to see a better understanding by both or by all parties of each other's roles, and for that to be able to filter down into everyday practice.
Hi, I'm Nicola Burgess. I'm from South Australia. I'm a solicitor. Very similar to Alison for obvious reasons. Very much in our state, we have had very little of this sort of interaction between legal profession and us, and we see a lot of problems. They just don't understand what interpreting is about. We're still being told, please give it a word for word. There's very little understanding of it. So that would have to be the reason.
I'm Dennis from Hong, a private interpreting service provider. I do agree with them. What I would like for the panel to discuss for better understanding from both sides on how to properly utilize the interpreter more often than not. Interpreters are not viewed as equal or professional. They're viewed as a tool but not as a person who they should use appropriately.
And that's one of the problems, using an interpreter
That's right.
as a tool.
Yeah.
Yeah, I have this view that basically we're talking, you know, lawyers are from Mars and interpreters are from Venus. And actually, if you follow that, you know, that culture of Mars is very rational. People run around in funny wigs and gowns. They're quite hierarchical, somewhat elitist. And actually, Venus was colonized by Mars a long time ago, so it's an imperialist power. And it treats interpreters a bit like Gastarbeiter. They're coming to do the necessary work, and they're largely disproportionately women. They're not paid very well, and they provide an essential service, exactly like Gastarbeiter in imperial society. But you know, their contribution is not valued, even though it's absolutely essential. And it's recognised as essential in all of the access to justice stuff. But there are Mars and Venus issues in all of this, and there is an overlap with some of the gender issues or masculinist cultures too. So,
I'm happy. I'm the Vice President of ASME Finance, which is the Professional Association for Sign Language Interpreters. And I think from our perspective, I take on board certainly the conversation happening and the interrelationship with is fantastic, and sometimes it does happen, I must say, in my experience. But more so in the health profession, I see mental health, it often is encouraged and supported in that area, not so much in the legal arena. But I do think that at the moment, certainly in the world of language interpreters, if you have your professional level accreditation, then you often do legal work regardless of having training in the area. And it does happen in healthcare as well. I have healthcare interpreters just go along and do work without any training. And I think we expect our professionals to have the appropriate qualifications and training behind to do the job. So I think it's about training people before, even if it's what we say, simple community legal appointment, things can become complex very quickly, and if you don't get fundamentals correct in the beginning, that can impact later. And also, I'm a really strong advocate of mentoring, and I think that we should be putting out experienced legal interpreters, Aussie interpreters, mentoring those that are having the training, get them to actually into court, see what's going on, get them familiar before they just decide to say, oh yes, because we do have code ethics, we really shouldn't be putting ourselves forward to do that we really want to do.
When I was at the Law Foundation, one of the projects we did was actually train up barristers as well as Auslan interpreters. And we did a whole mock thing, so both sides got a practice run at those and talked to each other. And I don't know whether that's been rerun, but we produced a set of materials and all the rest. One of the things that Aldous, who's the mystery man here in the front row, is trying to pull together some recommendations, because one of the things that Ludmilla and Sandra and I were talking about, it's very important that this sort of thing isn't a talk fest, that you have issues, that we try and come up with things that are very practical, that might involve some additional work, maybe some funding, that we can send off to the various bodies as a sort of a statement, a communique. So if you do have some concrete ideas, both for further work or indeed something that needs to change, you know, do feel free to frame it that way. And so mentoring has been the first suggestion that I think is nice and concrete.
Hi, my name is Amy. I'm from New South Wales. I'm interested in court interpreting because I have observed a few cases, and I noticed that interpreters, when they do court interpreting, is under big pressure, and often they have to react very quickly, and sometimes they make little mistakes, and sometimes those little mistakes can make a big change of the case.
Really can.
So when we notice these cases, some interpreters have to, because in the federal cases, there will often be 2 or 3 interpreters sitting in the same case and observing each other. And when we notice these mistakes, we should react. And sometimes we see interpreters to interpret for the witness, they were proving to really popular because something small mistakes.
So it is about accountability when you're dealing in language and you're dealing with a very low trust environment like courts. They are inevitably, by their nature, low trust. And also high accountability, high levels of expectations of transparency. Very complicated issue.
David Dick, in my case from Victoria. I like to ask this as a question later in the day, but I'll throw it in now. It follows on from what John Stever said, and it actually relates to an incident several years ago when I was interpreting in court. An interpreter turned up who'd actually had a hand in training through the new interpreter project, and who announced his profession, who announced his qualification as paraprofessional interpreter, and the magistrate said, "What's that?" and basically took him off again. So I suppose even just simple things like knowing what, that Ngāti hasn't said level 2 and level 3 for about 15 or 20 years, and yet you've got people out there who, unless they hear the magic words level 2 or level 3, will, they'd spend a whole lot of money getting this interpreter in, only to send him home again. So I suppose even just if you want practical things, something like everybody knows what paraprofessional and professional means.
Yes. Okay, thank you. That's all this is getting us, I'm sure. Yeah.
Hi, I'm Amelia Lamani from Adelaide. I think the big issue for me would be in terms of preparation materials for interpreters. So not necessarily mistrust, but definitely in terms of if we call in my agency or someone for a legal matter, court, or whatever it is, usually there's a very, very little about it. So I just can't believe there's an interpreter that needs competent. So I would love to see some sort of a breakthrough in terms of being able to receive things before something goes back in court. It makes so much sense to be prepared for these matters to bring the best outcomes. So I would love to see
folded in half in photo paper with a ribbon. Good.
Hi, my name is Erica Gonzalez. I'm a QTech here at UNSW. For me, the ideal would be that everybody, interpreters and the legal profession, understand that compulsory specialized training should be a must before accrediting. And I also think we should train new generations in the legal profession so that they understand that interpreters need to be well educated, well prepared, and that their job is going to reflect on the good job of the interpreter. So for me, I would highlight that specialized and compulsory training before getting the accreditation.
Okay, and I think you have to add that people need to be funded to participate in training rather than the other way around. It becomes a very complicated matter. Yes.
I'm Bob Hesse. I'm a translator and interpreter. I'm also an executive member. In an earlier life, I spent 10 years working in the Federal Court of Australia, so I have a long-standing interest in court work. Sandra and Ludmilla and others have done and are doing a lot of work with judges and others high in legal professions to sensitize them to the idea that we are not just handmaidens to their profession, but that we are also professionals and have needs and courts and special contribution paid. I would like to see that extended a little more to the law students, so that very few of them will end up on the bench, maybe only a minority of them will end up at the bar, but even the future solicitors among them will spend some time standing on their feet in the courtroom and will come into contact with interpreters. So I would like to start seeing that raising of awareness begin at the law student level.
And there's possibilities there. I mean, where I used to teach, we used to run groups, and it would be so interesting to have both groups participating with some groups with interpreters.
Yes, I'm aware that moot courts have been done, but they...
Well, I don't think they've done it with interpreting students.
Oh, I think that has occurred.
No. Okay.
But they tend to be one-off.
Sure, instead of integrated into...
And I would like to see some provision made in the curriculum for law students, so that all of them at some point in their course have perhaps a little sort of mini version of Sandra's course given to them. Just the elements of it, so that they early on in their career they develop some awareness that interpreters are not just, I like your term, Gus, not just people who brought in for utilitarian purposes, but actually have a professional role. And moreover, the quality of justice can succeed or fail depending on the quality of the work of the interpreters.
Hello, I'm Vicky Wong. I'm a PhD student doing legal interpreting. One of them I'm a legal student. I don't have any present issue, but I'm here today because I want to have a bit brainstorming as well as to be inspired. Subject to clearance, I'm interested in, for my PhD thesis, I'm interested in resources for interpreters from an interprofessional as well as an interprofessional perspective. So I have some brainstorming.
Fantastic. So there you go, panel. You've got some pressure on you. Up the back, whichever way you want to go.
Right. I'm Ellie Mariano from Western Australia, also on the articles. Mostly everything interests me what we've been talking about before, but I'm not quite sure if it is possible at all. But it would be wonderful if by the end of this session there would be an action plan there for bridging the gap. What I can see is that the INT project is going to have it to be wonderful for the future. But right now, in courts today in Australia, there are interpreters who never been trained. There are interpreters who just arrived in the country maybe 2 years ago. They just thrown in because there is nobody there. Language doesn't need execution. Could we somehow reach out to those who practice now without much guidance and facing ethical moral dilemmas like introductory create? Thank you.
Some further feedback? The long list of things that I'd like to see.
Choose the one that is just burning.
The most impossible one is to actually have regulated legislation for interpreters to protect them and to protect their clients' liability. I could have one there that was like the story about short problems to write. I am doing my doctorate at the moment. Simply because I'm a legal translator and I thought you shouldn't create things without doing it. So in this class we were supposed to do work together as a group. It's a multicultural class. We have people from different countries and quite a few young students just after their bachelor's degree. And we end up in a situation where our overseas students are being left in a corner and nobody wants to work with them. So our lecturer, who is quite fluid, says, okay, I want you guys who are local, I won't mention the university, I won't mention the town. Local guys, please tell me why you're not jumping across there. And very interesting stories come up, including I'm too scared to talk to someone who's not from my country. They're going to graduate within 2 to 3 years and become lawyers. They're too scared to talk to people who are not in their culture. There is a gap of, it's not about interpreting, there's a gap of cultural training that needs to go in this. That the world is not just my little country, my little planet, my little state.
Hi, my name is Liu. I'm also a PhD student of Professor Hill and Professor University. I'm currently researching into the accuracy measures in courtroom interpreting. Accuracy, yeah, what constitutes an accurate interpretation? Because people still have many different understandings for what's the definition of accuracy.
Have you found, how close are you to something?
I'm still doing my research. Hopefully I can have some useful results. And I'm also interested in what kind of training we need in order to better prepare the trainee interpreters. How to help them to effectively improve their interpreting performance in the courtroom setting. So these are the two topics I'm working on.
Very important topics.
Hello everyone. I'm also a PhD student here. This is my first year, and I'm interested in interprofessional relations and professionalism. Because I think one unique character of the interpreting profession is that the interpreters need to work with the other professionals, whether it's lawyers, doctors, or social security workers. Interpreters cannot finish their task only by themselves. Interprofessional relation is one key aspect of their profession. So I'm very interested in how interpreters as a professional maintain their professional role in this interprofessional relation, and how could this interprofessional relation affect the interpreter's practice, and what implication could we obtain from this, whole interpreter's professionalism. So that's why I'm very interested in, the topic of our this symposium. I'm keen to learn the perspective from the legal profession.
And there's another dimension of that metaphor of Mars and Venus. Mars is also imperial in other ways. It tends to overshadow other disciplinary groups as well, not just interpreters. So there's an argument that if you have a scarce resource like interpreters, where are they best used? So they use frontline before the problems arise in health, in welfare, and all those sort of sections. Or do you prioritise the temple of the law, and do you get your best people into courts? And what happens if you start to pay them more, if they become, an elite group that work in courts? And what happens to the rest of, the bigger system? So these are also issues around professions and disciplines, which I think the law, Mars, has to grapple with more generally. And so there's someone in that corner that you could be a technician, but I don't know.
I'm a technician.
Well, actually, there's probably some good scope. We will have some examples, I think.
Got a question from online, if that's possible.
Oh, question online. Oh, wow. I just feel like, whatever the Q&A. Go on, please. A question from...
So we've got a question from Julie S.
Yes.
How do I convince legal professionals, especially the DPP, of the need to supply interpreters with material before trial?
Okay, so that's a repetition of the other burning issue. That seems to be emerging, both professionalism and all the things associated with mutual respect of a profession seems to be something that's emerging. Okay, no pressure panelists, I'm coming back to you. Is everybody okay with the temperature here? Yeah, it's all right, it's a little bit humid. I was reminded as I was thinking about this that I was in Hong Kong quite some years ago, and on the air conditioning there was a translated little note that said, if hot or cold, control yourself. And it's a joke, but it's also about the nuance of language, and in particular the nuance of how I said that. And so the subtleties of language are sometimes the issues that both lawyers and interpreters have to deal with, and in fact they're both masters of that nuance. And so if it's too hot or cold, just control yourself. We'll come to the question from out there. How are you and the rest of the millions? I hope you're doing well. So I'm now going to turn to our panelists who were incredibly diligent because they sent in their questions. So they've got notice. We briefed everybody in the entirely appropriate way, totally transparent. They all knew what they were asking. So we have on the little doobie.
So the first question is up there.
The first question, but before we just do that, so you'll see we also treat you as our expert panel. Everyone here is an expert. We just had to give these people more work to do early on. So if the panelists might like to just briefly introduce themselves, and we won't ask them what their burning issues because they're all up here. Is it possible? We may not be able to see it, but it might get too dark in here. Do you think that's better? Very dark? Still too dark? No. Okay, well, can you see it? Is that right? Yeah. Okay, but I will just ask the panelists to tell us where they're from and what their primary experience is, and we've mixed them up, so there's not Venus and Mars, they're all into working. Susan, please.
Good morning. I'm Sue Smith from VCAT, which is the Victorian Civil and Administrative Tribunal. And I sit predominantly in lists where there are unrepresented litigants. So I don't deal with that tension between lawyers and the bench, but I do deal with interpreters a lot. And we have a strong commitment to ensuring a fair hearing. But it has been my impression over the past 22 years, I've been at crisis point in believing that we are not getting a fair hearing. We're not getting the best from our interpreters, and certainly our members are not getting the best hearing that we could possibly have. We need, and I'm looking at this from the point of view of training members and training interpreters and training our staff and trying to ascertain how we can give the best possible briefing but not undermine the process. And that's why I'm here, because really I'm going to get as much information from you as I possibly can to be able to feed back into the organisation. I have to try and get the best hearing that we can and the best use of our interpreters that we possibly can. So I'm probably a contributor to a lot of the frustrations that interpreters have, and I'm happy to be guided by you into how we can improve that in our hearings. Very short, quick hearings, as some people have experienced.
There's also, I think, a corollary, which is sometimes the idea that if you have an interpreter, then justice will prevail. That is, you can fix all the issues of disadvantage and all access to justice by, oh, well, if they've had an interpreter, it's all terrific. So, both sides. Sean.
Good morning, everyone. My name is Sean Cheng. I'm a teacher here at UNSW, teaching translation and interpreting. So, in terms of this question, assessing clients' English competence, I experienced, but not in terms of English competence, but also in terms of Mandarin. I was once a witness who could only speak a dialect and had limited Mandarin competence, and I was asked to try my best to interpret, and I was actually asked to sit in the witness box to give evidence as an expert witness, to be cross-examined by the lawyers, to say, can you say that witness language is competent enough to express herself or not? So I was put in this situation. All I could do was to say the same thing as the video critic. I'd say I'm a professional interpreter, I'm not a judge. I'll try my best to understand what she's saying, but I will not be able to tell you whether her language competence is good enough to give evidence or not. But my question is, will other people, will the court, will the lawyer or other people be able to determine the witness language competence through the interpretation? And what should the interpreters do to reflect whatever's been said with limited language competence?
Well, maybe because we have that first question up there, if the rest of the panel don't mind for one moment, maybe that's a good place to start. Assess, how do we know that a person requires an interpreter? How do we assess, as Sean has said, whether the witness, in fact, and the interpreter are speaking a language that is common? Whose responsibility is? And I know, just moving across here, Pamela Jenkins and Susan at this end both had this issue. Did you want to pick up the point, Sean? Did you have a particular example of that, or an issue that you want to raise more broadly?
I think this can be a real issue in criminal trials, in particular. And I can give many anecdotes where an accused person will be said by the police to have sufficient comprehension of English. They've been able to talk to them without any difficulties, and then as soon as they get them into a regular interview situation, hands up for an interpreter or into a court, they can speak very little English. Now, there can be a number of reasons for that. either their, or a range of reasons, wanting to not acknowledge the extent of their comprehension, and or secondly, a court environment and the language used in court is confronting people with English as the first language. Compound that with the more limited comprehension that a person might have even with conversational English, you can well understand why they need an interpreter. But I've had a number of situations, and one quite recently. I sit on the county court in Victoria, but I'm currently allocated to VCAT, and I had a recent case involving a Chinese gentleman who, at the beginning of the hearing, spent about 3 or 4 days, insisted he, through his interpreter, he virtually had no English at all. By the end of the last couple of days, he dispensed with the interpreter and was speaking perfectly flowing English. There's a number of reasons why that happened, but there was no way that I would have been able to tell, certainly no way that the interpreter was able to tell what his comprehension of English was. He hid it very well. So there can be some quite significant forensic reasons, say for the defence or the prosecution, to know what a level of a person's comprehension is. I think this whole issue also, this question raises an issue of, and I'm not sure this is going to come out in some of the concerns that have been raised, but whilst there certainly needs to be more training of students and recognition of interpreters, professionalism and so forth, equally there needs to be more training and appreciation within the legal profession, within the judiciary. I think there is a more acute awareness within the judiciary and legal members of tribunals than perhaps we give them credit for, because we're dealing with this all the time. We see all the problems. I've had the most fantastic professional interpreters. I've had the most awful interpreters who have caused terrible problems and possibly even miscarriages of justice and don't even appreciate. So even at the same level of paraprofessional or professional, you get a wide variation in competence. A lot of that has to do with familiarity in particular contexts, and I think the point that was raised earlier about training for the health sector or for the legal sector is terribly important. You can't just have the qualifications in a particular language and expect to walk into a court and do an appropriate interpretation. So this is getting off the question a little bit, but I think we need to also examine where we are inadequate in our training across the board. The requirements for an interpreter varies. The demands for an interpreter varies according to the particular context. In a criminal trial, what they should do is quite different, and I can expand on this perhaps a bit later, is quite different to what we would hope they can do in a guardianship hearing or in a civil trial. And what an interpreter needs to know in advance will equip them significantly in their duties. Their duties, as far as a member or the judge is concerned, is to the court, or just to the tribunal. It's not to whoever is paying them. And I think
that's coming up, but there's a question.
Yeah, I just have a question. It's to do with this question of competence. Because the Evidence Act allows for the use of an interpreter for some and not everything, it's not that on-off switch that we used to have on. Have you seen in your experience that people actually explicitly saying, I don't need an interpreter at this point, but I will need one when I get to this, to cross-examination, when we get to this kind of...
That's very common, yeah. It used to be, I think this attitude has changed, but certainly an attitude when I first started, that you would require, or making, putting it too strongly, but strongly encourage a witness to answer in English if they could. And often I've said it too. Please answer in English if you can. If you feel you need the assistance of the interpreter at any time, ask for it. But there was, a subtle pressure put upon witnesses to answer English. I think our appreciation has become a bit more sophisticated now, and we would prefer if people rely upon an interpreter more, because it's just too hard for people, or too hard for us to really be confident that people are understanding the questions. So there's no difficulty at all for people answering when they can, and often we would find people using the interpreter, and then suddenly they'd answer the question, and you realise that they probably did understand half of what was being said, but not all of what was being said. So they could answer simple questions, but not more complex questions, and certainly not questions that involve legal terminology. And so much that we just take for granted. We don't even think of as being unique to the court, but often it is. And that's where interpretation is invaluable.
Can I just ask a question that I know the answer to, I think, which is primary rule of cross-examination. How many of the lawyers here think that they, as lawyers, are disadvantaged when a witness or a client has an interpreter? Of the lawyers, put your hand up if you're a lawyer. Put your hand down if you think that you are disadvantaged as a lawyer doing your job if the client works through an interpreter.
Sorry.
Down. So I'm going to say
up for disadvantage or up for...
if you as a lawyer feel as though you're getting less good quality stuff where there's an interpreter for that client.
We put our hands up.
Oh, I'm sorry.
It has to be. It has to be. If you don't speak the same language as a first language as your client, there's a disadvantage. An interpreter can't make that go away perfectly in all circumstances, so there has to be some
There's always
disadvantage.
going to be disadvantage. Most lawyers, if you ask them, I think privately, would say they feel, at both as cross-examiner and even for examination in chief of your own client, they would say they don't get to see the real person. And in cross-examination, they think the delay disadvantages their forensic capacity to really get to the truth.
Especially if they understand the question in English in the first place.
Yeah, so
I
then
guess the other side of that is if the person's first language is not English and you don't have an interpreter, the disadvantage is enormous. So
the disadvantage is not from having an interpreter, the disadvantage is from having a non-English speaker. But I guess forensically in that cross-examination example, that's an example where there is a forensic disadvantage because of the interpreter.
So there's a general view, I think, among lawyers that, yes, of course, they need an interpreter for access to justice, but there is also a sense that as lawyers, their main skill is through language, and somehow or other that's not getting there. What about, and I think Pam's example is a good one, clients sometimes think that they may get a slight delay advantage if they understand but then have it interpreted. But pretty quickly, as in that example, they sort of work out that they've lost their own control capacity to be themselves, to respond in their own voice, and so they might switch. So it is a game, but the idea of whether or not it's an advantage or a disadvantage, I think, is something we need to think through. Yeah, Sandra.
Sorry, can I say just a few things? I think the responsibility to decide on who needs the interpreter is the person who cannot speak English. I think, you know, all those other considerations are minimal because of things that we were saying. Now, the important thing is that the interpreter needs to be a competent, trained interpreter. If the interpreter is trained in legal interpreting, where they're trained to maintain the same style of speech, the same register, the same techniques from the lawyers, this is what we train interpreters. Very few of them are trained this way, but if they are trained this way, then the disadvantage or the intervention will be minimal. So that's what, and I've done a lot of research into this to try to minimise that intervention from the interpreter that will make that difference. So the better the interpreter is, the less that intervention, so the less the advantage or disadvantage. And the research has shown this, that when interpreters are fully accurate at all those levels, so they maintain all of the nuances, the techniques that the lawyers use the answers in the same hesitant way or forceful way or whatever the original is, there is no significant difference in the evaluation of credibility and trustworthiness and all those issues. But when the interpreter either improves on the original or does the opposite, make it sound more hesitant and so forth, then there is a disadvantage if they do the opposite, there's an advantage if they improve on it. So the interpreter has a huge role there, and we go back to the need for training, the need for specialist training based on research, and the need to pay interpreters accordingly, because if they don't get paid, unfortunately, they will not continue to work. And so we're going back to, okay, we've got a bit of a Band-Aid solution there, but it's not a real solution, because the effect that this may have is, unknown.
So the takeaway evidence-based is the more skilled, more qualified the interpreter, the less the interference or disadvantage from linguistic communication issues. But yeah, that's the critical thing. How many girls?
Yes. Just to add to what Sandra has just said, I've heard the word delay several times here. Now, without wanting to jump ahead too far, can we suggest that perhaps a different interpretation mode, namely simultaneous interpretation, which is used, for example, in international courts, would help solve the problem of delay and the loss of dynamic of cross-examination in particular. Again, if we adopt this view, it would be impossible to implement unless there is training and unless there are resources put into it.
Except for one thing, Lord Miller, and that is where direct translation, I'm not really interpreting, but direct translation is not possible because of conceptual gulfs between the two language groups, between the two languages. In which case, some explication and explanation is required as part of the interpreting process, and that makes simultaneous interpreting impossible.
Except, again, this practice has been used in international courts with various vernacular languages, such as African languages, and different techniques have been adopted top-down by the court to accommodate that need for explanation or requests for clarification, repetition, and so on.
So you kind of put up a signal and say, I now need to explain.
Or you address the presiding judge in the microphone. You develop glossaries. So it cannot be done in an ad hoc way. It has to be done by the court or by the legal system.
But simultaneous interpreters, I mean, they're top scale, they're pretty...
They employ for African languages, they employ people with very little interpreting experience in international settings. They train them in-house.
Jeff had a comment?
I was just to get back to my original point, but to some degree there's also the context of, can the lawyer, judge actually speak in plain language anyway? And I say this is quite serious, because this is where the context comes into understanding concepts. The average Australian does understand most of the legal concepts, legal phrases. In fact, I was speaking to the chief magistrate here some years ago. I said, what's your number one big problem? She said, we give out to, and whenever we issue an AVO, we give out a list of paper and explaining what it is, but most of the generally men don't actually understand what's involved. And it's whether we're an English speaker or not. I mean, we had you can probably find it on YouTube. We funded 4 documentaries years ago called Do It Yourself Law. And one of those 4 30-minute episodes was in the Migration Review Tribunal. It was basically my family migration. A Cambodian refugee who got approval to try and bring a mother across. She spoke quite good English. But the interesting thing was, it was a documentary. It was fly on the wall, so it was an actual case. And when the MRT member delivered her decision, I don't think, unless you actually had really good knowledge of the Migration Act, you would have actually understood what she said. After she walked out and the camera looks at the woman goes, I don't know what happened. And she walks out, and obviously the member felt a bit guilty because she thought, oh, I've been on TV, I better actually go and do it. So she catches up to her in the corridor and tries to, in plain language or whatever, explain to again, still no one will work out what the outcome from that was. It wasn't until she went to the receptionist at the MRT, and the receptionist picks up and goes, "Oh, you won." And so I think the context is that, and a lot of, okay, the court matters are obviously the most important, but I think you'll find that there's a whole lot of matters prior to that and around that, where actually the context the interpreter is also working in is when the average person, and the average interpreter probably doesn't understand, unless they're really trained, these legal concepts, but is the lawyer, judge even speaking in plain language that an ordinary English speaker would learn? And you throw the interpreter into that context and how you manage that process and those concepts. I think that's got to come out. I think that's a contextual issue.
And whether it's even possible.
Yes.
Would a judge be prepared? I don't know what the judges think. Can they, in fact, get away and put it in other terms that are lay terms?
Yes, they can and they do, and the barristers absolutely hate it because, I mean, frequently my colleagues at the end of something, no matter, where we've had to deal with sort of technicalities, legal issues. I've said, now, can I just explain what's been happening? I'm sorry we've been dealing with these technicalities, and I've talked to the person in the dock or the clients, and you can see the temperature of the barristers rising because it appears to them to be an affront to the client. I've been talking to them, I'll explain to them what they need to know. Because I fear that strong attitude. I don't think we're going to get away from complicated language in courts anytime soon. We've just about got rid of just Latin expressions, and that's a disgrace that we're maintaining as long as we did. But we've got a very long way to go with converting to plain English, and there's no reason that can't happen. There's no reason that judgment shouldn't be comprehensible to lay people for whom they're directive. At the moment, they're still directing to the court of appeal.
Yes, please. If you could introduce yourself.
Yeah, I'm Liz Beoff. I work at the Legal Aid Commission, and I generally work in the area of immigration law. So I'm using interpreters maybe 4 or 5 times a day, and I work at all levels from primary decisions up to the High Court. So I really second what Sandra's had to say in that the quality of interpreting depends on the training. And for me, it's such a delight when somebody comes in who's been trained and really understands legal practice, in comparison to somebody who's been interpreting for 20 years, has some language skill which may be outdated, but doesn't fully understand what legal interpreting means. The other side, though, I think, is there's no training for lawyers. I mentor, and for many years have mentored young lawyers at Legal Aid. And in the practical legal training degree, you do all sorts of legal training. You learn about accounting, you learn about keeping files, you don't learn about using an interpreter. And to me, that's the big gap in legal training. It's not something that needs to be done when people are at uni, but it's when they're doing that last stage, I'm about to finish this diploma, and then I'm going to go off and be admitted, and I'm going to be sitting with a client. That's when people really need training, and they need to sit in. What we do at Legal Aid is we often have our young legal students, people who are doing their PLT with us, or people who've just come as interns, sitting in on interviews, listening to people use interpreters, and talking about that after. And there's really simple things that lawyers need to do, like ensuring that the client knows what the interpreter's role is and that it's all confidential. And yet these basics are often glossed over because the lawyers don't understand what they have to do in working with an interpreter.
Can I just ask a question from people here who may have better experience in this? If you're not dealing with a largely monocultural, monolinguistic community like Anglo English speakers, is it easier for, let's say, European judges to understand the complexities? Is it about, you know, at the fact that most people don't speak other languages, that they have such difficulties comprehending this? Does it work better internationally? I don't understand. Miller, I don't know.
It works better internationally because everybody comes from a different culture and everybody has to adapt to this recently created legal culture, whether it is the International Criminal Court or International Tribunal for the former Yugoslavia. So everybody's pretty much in the same situation, despite the domination of Anglo lawyers and judges. At the International Criminal Court, there are lots of lawyers and judges from non-English speaking cultures. So there is this additional effort made. Now, what is noticeable, though, that the awareness of these problems doesn't necessarily translate into practice. But again, I have to say that the main offenders are Anglo-Saxon judges and lawyers.
Okay, it was an interesting thing to think about, Elise. Yes, sorry, David.
Can make two observations. My interpreting languages was Indonesian. I sometimes get the impression with some of my clients that they're trying to answer in English because they feel that it's a bit disrespectful to use their own language, and quite often I have to say to them, look, you just answer in Indonesian, I'll do the work for you. That's one aspect. The other one is, and this is in fact the first police job I ever had. In fact, I was down in Geelong and went all the way up to Green Waverley to be greeted by the police, and he said, oh, I've been talking to this guy and I think his English is fairly good, so you just sit in and you just come in whenever there's a bit of a miscommunication. So what was I supposed to do? You know, I could see at a whole lot of points that I thought there was a miscommunication, but it's very difficult to then, if you haven't been interpreting up till now, to then come in and say, excuse me, I think at this stage I need to interpret. You know, I don't think it was a good position to put
that is one of our panel
Yeah.
comments. If we could move to that one.
Yeah.
Just
what needs to be?
No, that point that we've just had. No, keep going. But the pressure on interpreters in various settings to be able to say, now I want to say that client really didn't understand that, or just hold on, I need to explain something that there's no conceptual, linguistic or cultural issue. What do we do about that problem? So yes.
I was in the Northern Territory in court last week in Sheffield, and it must be an issue. Monolingualism of judges, and they need to recognise how much their language is alienates. When they're doing summing up or they're speaking to a defendant, these are members of an Yalda Aboriginal language speaking community, they're using words like predilection, and they're using words like, talking about the sentence that is disproportionate. There really is a big gulf between people who are virtually not speaking English at all and judges who are monolingual.
So have you ever interrupted and said, I'm sorry, is there a simple word that you could use that I could translate to a judge? What would happen if that happened?
Yes, I have.
Yes, not so much to a judge, but sometimes to a lawyer, ask them to reframe the question. Or in the case where the question may be simple, there can still be confusion. Like commonly in cross-examination, you have an assertion and a tag. So you didn't go in the boat, did you? Now, if the person is denied an interpreter and a second language speaker, they may focus on the assertion, you didn't go in the boat, and say yes. But the real question is, did you? And so there's confusion. And so sometimes in those kind of questions, I have to sort of explain what's going on.
And yet the comments that were coming were around this, the pressure on interpreters because they're reluctant to interrupt, seek leave to clarify, or make a statement about the lack of equivalence. So, Della.
I don't think I've ever had, I've sat in courts and I know the interpreters. I don't think I've ever sat in court and heard an interpreter have a voice. And maybe as you're saying, can you clarify the question, which is not quite adequate. I don't think I've ever heard an interpreter have a voice. I'd be curious as to know whether people in the room who are interpreters feel that they have.
Yeah, I think that's also one of the parts we focus on training, on how to manage the communication flow And actually research says that also humility to ask for clarification is a good skill in interpreters. Now, I think the big difference here is the levels of entry into the profession for interpreters. On one side, we've got professionals who've done a master's degree, who've studied common law, civil law, and know the adversarial court system, for example, different courts and tribunals. And on the other side, we've got professionals who sat for a 75-minute exam and maybe passed the exam and got out. It's impossible for some languages, for example, to access a university course, because we've got European languages, some Asian languages, but for example, we have nothing in African languages, so at least the accreditation is something. Now, in the accreditation exam, it's a pre-recorded dialogue. There you cannot manage the flow of the communication. You can ask for a repetition and that's it. So again, I think resources need to be thrown into training so that people from other languages which are not Spanish, French, Indonesian, Mandarin, Korean, and Japanese, and Auslan can also have access to good quality training in order to be able to interpret accurately and as
So you're really saying that this is solved by having a confident, highly educated interpreter who can...
With respect, I don't think that's true. I'm a lawyer in court. I find it difficult at times to have a voice. So, and I know the protocols. I would think if I put myself in the interpreter's shoes, I would feel more confident that I could have a voice in the terms that you're talking about if at the start of the proceedings I was given that license, that the judge or the magistrate or the tribunal member said, Mr. Interpreter, if I say something that presents you with a difficulty, you have a license to speak up. And maybe have, if it's a long trial, maybe have that reinforced each day or something. Because otherwise, I mean, you've all been in courts, you know how intimidating a courtroom is. It's very hard to speak up out of turn. I mean, I can speak because my turn has come. Mr. Foley, do you want to say something? And I shut up until it gets to that. But if I didn't have a license to talk, I don't think I would say anything. And I agree, I compliment the people who feel that they've got the personal confidence to do that, but I think that's a rare person.
There's just one comment there.
Yeah.
Because I also want Philip to introduce himself too.
I'm also an interpreter, including in courts. And I find courts are places where talking is taking place the whole time. There's a lot of really poor communication, which makes it hard not just for interpreters, but for anyone who's not trained in the room. And this issue of trying to get clarification, there's been cases where the magistrate has said to me, I'm sitting next to the defendant, he said, the magistrate said to me, just let me know if there's anything he doesn't understand. And I said, well, and how would I know that? And he said, well, he tells you. And again, culturally, it's very unlikely, in this case, an Indonesian person would let you know they didn't understand, where most Australian native speakers also would be very confused in that situation. So courtrooms are generally unhelpful to everybody, not just for interpreters, but it would help us if we got the fact sheets and indictment and so on in advance. Just one other thing on simultaneous interpreting, which I think also would be much better used in courts than consecutive interpreting. Someone said, well, those are the top people. Well, not necessarily, it's simply another form of interpreting. And it can be easier than consecutive interpreting because you don't have the memory problem. It will take more money if you pay interpreters more and provide the equipment. But for instance, when you have someone in the witness box all day, it'll only be half a day if it's simultaneous. So really, it'll be cheaper.
Okay. Sandra, oh, and there's a return there. Let's, Sandra, and then, I'm sorry, I don't, David. And then we have a short segment we'd like to show you that I think Sandra has been working on, which is really the protocols. We've now got to the point where instead of, everybody whinging about this all the time, fortunately we have some academics who've been working on a national protocol if they're trying to get some traction on. So we'll do that. But Sandra's got a comment, and then David's got a comment, and then we can show it. Or do you want to?
Oh, I thought maybe
David, do you want to do your comment first then?
I just don't think anything will change until some kind of linguistic professional is appointed to the court to make the call about whether the person needs an interpreter. This is what we need in the Northern Territory. In this generation, there will never be anybody who's good enough to jump in the way of the judge and say, Your Honour, can I interpret this? It just won't happen. It's simply unrealistic. Fine this problem. What we need is competent linguistic professionals to be attached to the courts to make those kinds of judgments. The judgment shouldn't be made by a monolingual judge who has no idea of language comparison and how different these languages are. English being very different from Aboriginal languages, more different than two European languages are from each other. This kind of thing needs to be addressed seriously. Why should there only be one linguistic professional in the court when there's 5 legal professionals?
Okay. Yes, a little bit sideways, but I understand your point. But I thought this is the time to announce this, because not many people know about this, that there's been a Judicial Council on Cultural Diversity recently formed, chaired by the Honourable Wayne Martin, Chief Justice of Western Australia. And some of you may know about the AIJA report that I wrote in 2011, where one of the recommendations was for a national protocol. And back then I was told, no, that's impossible because all the states have their own different jurisdictions. So some of the states started creating their own protocols based on the recommendations there. And now they've decided that they do want a national protocol. And I've been asked to write this with a retired judge, the Honourable Dean Gilder. So we've started writing that, and it will be hopefully finished by next year. And I hope that a lot of what we've been saying will be incorporated in that. Now, the implementation of the protocol is the next step, but once it's written down, then it is a major breakthrough, I think, and I'm really pretty keen to start this going and very optimistic about it. Now, I wanted to show you a couple of clips. These are clips from research projects that we've done, funded by the Australian Research Council, and we created a whole mock trial where this is just segments, but we tried to use the best protocols possible because we didn't want that to be a variable. I won't tell you about the whole project, but this is an example of the type of introduction that a judge might be able to do in order to give the interpreter a permission to, intervene when needed, as Tony was saying. So can you see?
Thank you, Madam Interpreter. For the record, could you please state your full name and level of accreditation in interpreting?
Yes, Your Honor. My full name is Julia Ortega. I am accredited at the interpreter level by the National Accreditation for Translators and Interpreters, NATI, in English and Spanish, which is the highest level for interpreting in court. Here's my card.
Thank you, Madam Interpreter. Do you have any formal qualifications in addition to your NATI qualifications in accreditation?
Yes, Your Honor. I have a Bachelor of Arts in Linguistics from Argentina and a Master of Linguistics in Interpreting and Translation from Australia.
Okay. Please let me know if you need anything during the course of the trial to assist in your ability to interpret.
Okay, now the reason why the introduction is important, not only the judge asking, telling her that if she needs anything, please let me know, but also the status of the interpreter. If the interpreter is not introduced, the interpreter does not have a status in the court. If the interpreter is introduced as a professional, then the interpreter is part of the professional team. It's also got to do with the jury. I'll show you the next clip about how he talks to the jury about the interpreter, but also in how to assess whether the judge can, or those who are using the services of the interpreter, whether they can fully trust this interpreter if they have the qualifications. If they say they don't have anything, then you have to be more alert as to, okay, maybe this misunderstanding is due to poor interpretation rather than to the person not understanding. So, having a knowledge of the qualifications of the interpreter should be, something to help those who use the services to determine how much they have to, be alert to what can go wrong. Let's have a look at the next one. Okay.
Now I'll explain how the interpreter will work. When Mr. Lopez gives evidence, the questions put to him and his responses will be interpreted by the interpreter consecutively. She will interpret faithfully what Mr. Lopez says. When others speak, the interpreter will interpret what is being said to Mr. Lopez simultaneous mode by whispering in his ear what is being said. If at any time you do not hear the interpreter or misunderstand anything, please raise your hand and I'll attend to it.
Okay, obviously that's what happens now. There's no technology, but what we're saying is that technology can be used, and there's portable technology that can be used that's quite affordable, that interpreters can take around with them using infrared technology in the court. There's another segment that we won't show where the interpreter actually needs to ask for clarification, and we showed how that happens. Now, Tony, back to your question, I have seen interpreters ask for clarification, stop the judge, and they have been interpreters that have been trained. And I was as part of this research, we went observing different courts, and I was very, very heartened by one trial that I saw, and actually a committal hearing with a magistrate. The magistrate had been trained by me in one of the training sessions that I do for magistrates and judges, and the student, the interpreter had been student as well. And it was amazing. They didn't know I was there. They didn't know I was there to watch them. How everything
grade them.
So grade them, yeah. But everything they did was exactly what they'd been taught, and everything ran very smoothly. And the magistrate gave the interpreter, or spoke to the interpreter as an equal professional. The interpreter stopped a number of times to ask for clarification. The lawyer spoke the same language as the interpreter and questioned the interpretation a couple of times, and the interpreter had to justify her rendition. It was an Arabic interpreter. So it all worked out, and it was really, as I said, really rewarding to see that it can happen. But it needs the cooperation of everybody involved. So I think I'll stop here.
So the protocol issue in all sorts of areas we now know seems to help people. They don't have to reinvent the wheel, every time. What about protocols about briefing? Are we closer? Because there are two issues that were raised earlier. Has anyone had good experience with briefing? I want to hear about a model one. Yes.
I'll just checking, right? As an alternative, good briefing has come from other interpreters where you're working a trial and you're coming in on the third day and your colleagues brief. Very rarely the lawyers that you work with. I mean, of course, if you have the luxury of being involved before the court day, you start to get a sense, get briefing basically through the legal process leading up to the court case.
So, okay, are we close to being able to say what constitutes good briefing?
One point is for the interpreter to have the opportunity to have a short conversation with the client before starting to interpret, just to check that they have the same dialect, understand each other, accents of. Okay.
So that's certainly got to be one part of it. But what about, do the lawyers not brief because they don't think it's important, or because they don't have time, or why are the lawyers not saying, this matter is about so-and-so, we're trying to do this, or, why does that not happen?
My exposure is in the magistrates' court, so they're really, I would have, the situation may be this, that I may have attempted to speak to the person whose language is not English, and it's clear to me I can't have a conversation. So I then go up to court from the cells and look to see whether there's an interpreter called. And often the matter is called, the client is brought up, totally confused as to what's going to happen, I would have thought, because I haven't spoken to him. And then the three of us suddenly appear at the bar table. The interpreter not knowing what's going on, the client not knowing what's going on, and I haven't had a conversation with anyone. So it does seem to, but the advantage I have over the interpreter is that someone has given me a set of papers, and I've had the chance to read those. And the interpreter has certainly not been given that, and I'm not certain. I'd be interested to hear from the tribunal members and the judge about whether they think that's my responsibility or whether I have to. I would think I have to wait to be told to be showing pieces of paper to the interpreter. That's why.
That's certainly the position I would.
Okay.
That you have to wait?
I think that a limited briefing, and that might be on terminology but not the particulars of a matter, is appropriate. But I see it as a protection for the interpreter and protection for the integrity of the interpreter in the tribunal, that they are not exposed to information prior to coming into the tribunal. That's the position I think.
Yes, I endorse that too. I think otherwise they become a participant and their duty is to the court or the tribunal. That's not to say though that they might be made aware if they're not already of certain terminology, and that is absolutely critical. And I might say also in the lengthy trial, and the trial goes on for a day, it's so critical to maintain the same interpreter throughout. And many times, unfortunately, that's not achieved. I've had trials with 2 or 3 interpreters where there's been the same witness throughout that period, and it's very disruptive for that witness in the trial in general.
So I've got Aldous has not spoken. That's why I'm trying to go to.
You asked for a good example of briefing. I don't interpret in court much, but I received a 3-paragraph briefing from the federal DPP. It was in a context where they contacted me directly, because what happens is that agencies don't ask for briefings, and the interpreter normally gets this work through an agency. Because of this direct contact, I actually wrote to them, asked for a briefing. I got 3 paragraphs which perfectly gave me what the context of the matter was, and they said that if it gets to a further stage, the solicitor would give me further information. It was a mention situation. But I think 3 paragraphs on a mention is quite good. Now, interpreters don't ask, agencies don't ask. When the defence lawyer came in looking for me and the interpreter, it did not enter his mind to give me a briefing. And if I hadn't had that briefing from the federal DPP's office, I wouldn't have known what the defence lawyer was talking about.
So Ludmilla, you have to inject with some evidence and research, or no?
Well, I wasn't going to, but I just wanted to say that interpreters in conferences routinely get ample preparation materials, because it is recognized that unless you have some briefing and preparation materials, you cannot prepare linguistically, conceptually for the assignment. Now, what I find also interesting is that in courts where interpreters are employed full-time, where they are on staff, they have unlimited access to the in-court databases. And not only in international courts, but also in domestic courts like Singapore Supreme Court or federal courts in the United States. So I wonder whether the caution on the part of the lawyers and judges in terms of over-supplying preparation materials and briefing has something to do with the lack of trust in interpreters who are employed on a casual basis.
I've often been in the situation where I've assisted the lawyer and their client in taking instructions, in the client giving instructions, and then gone into court to be the court interpreter. It's presented no difficulty because I'm very well aware of the ethics that the interpreters have to follow. It makes no difference to the way I do the job.
So I'm looking, all the judicial officers have got these sort of scowling faces. So let's hear it. Let's hear the elephant in the room, and then listen after I've just at the comments from the judges, maybe yes. And
from
we
the
do
defence
Defence,
criminal lawyer
absolutely.
point of view, I mean, there's several different ways that interpreters are used in, say, criminal matters. We've got, when I'm speaking with my client in conference, they're usually going to be fairly well briefed by me, the interpreter, so that they can be across what I'm going to be talking about with my client. Then I get to court, and there's a court in New South Wales, there's a court appointed, in state matters, there's a court appointed interpreter who sits next to my client and helps them in court. Sometimes I can use them for conferences, sometimes I can't. Commonwealth matters, that interpreter is supplied by the Commonwealth DPP and usually can't use them outside of court. And then there might be, if there are witnesses who speak different languages, then there are witnesses, if they're Crown witnesses that I have absolutely no access to, those interpreters are going to turn up with the witness and they're being used. So there's all these different contexts and all different lawyers and people who may or may not be in a position to brief interpreters. There's certainly a perception, I think, that if I've had 5 conferences with the same interpreter with my client, and then I want to use that interpreter who would be in a fantastic position to, in one sense, to know all the issues and so on, but there's a real perception from the Crown and the bench, quite rightly, that there might be some sympathy there. There might be non-intentional corrections, hearing what they think they said because of the previous knowledge, not what they actually said, and things like that. So there's real issues, and that's why I think what you were saying was there's a real danger from our perspective of having people have too much involvement with any particular party.
Yeah, my concern is because I often act for asylum seekers who have specific claims, and they're often linked with political terminology or religious terminology. And I will specifically ask for certain interpreters, and there are some fantastic ones who have gone through and have worked out their own glossary of religious terms or political terms, and they can be fantastic in a conference. We can get the statements done very quickly. The client then feels quite confident that their issues are being understood. This is completely undone when we get to the tribunal, and the tribunal has appointed an interpreter who has absolutely no idea. And so the person is there, ready to give forth about what their fears are, what their claims are. And the poor interpreter has no idea because they have no concept of what some complex terms linked with a specific religious group from the Middle East may be. And the tribunal member gets frustrated. The other issue that we haven't dealt with yet is often there is too little time. At the migration tribunals, there's 2 hours or 2.5 hours set, and then you'll get the member after about an hour and 3/4 getting, well, could we just hurry up? Could you hurry up, please, Madam Interpreter? Because they know they've got to be out of that time because somebody else has to come in within 3 hours with a new tribunal hearing. So time is also another factor.
So just Jeb, and then I'm just going to ask if we need a quick blue break or something.
Just a philosophical question. I mean, all those practical points, but just a philosophical question to the judicial officers about releasing information. If the client has, if the accused or the client has access to information, why wouldn't the interpreter have access to information for it? Because if that is simply the means by which the client actually is supposed to understand the information, the charges against them, whatever it is, the evidence, whatever. If the client has access to that information, why wouldn't the interpreter?
And it's heard in open court anyway.
And why wouldn't that access?
So on that point, can we just have that 3-4 minute break, however long it takes, and think about if, despite the complexities, is it possible for us to think about protocols around briefing and preparation on both sides, beyond the training question, but actually in individual cases? Okay, just a 5 minutes, is that all right? Yeah. Sorry. And out there in Homeland, you can think about that question too.
that would be my instinct.
Oh, okay. Yes, yes, yes.